3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time, we walked through the intelligence question. Today, we are following the blackmail theory through the documentary record, so the timeline, decisions, and institutional failures are clear. As always, every document and source we reference is available at epsteinfiles.fm. So start with surveillance systems documented. That is where the paper trail becomes specific and testable.
Exactly. And we have to be extremely precise with our parameters here.
Okay.
The word blackmail, especially in this case, it gets thrown around a lot in the public conversation. It's almost become a narrative device, a story about secret tapes and hidden cameras.
A movie plot.
A movie plot. That is not how we're approaching this. Today, we are auditors. We're looking for the paper trail. We're looking for the receipt.
The line item?
The line item in a government filing, a court transcript, a deposition. Something that takes this from a theory and turns it into a documented asset, a known variable.
So to do that, you have to start with the basics, the physical infrastructure. We can't talk about the why or the who until we've established the how.
The capability.
The capability. And the primary document for that initial assessment is labeled EFTA 0002403.pdf. This is a document from the pinpoint database of Justice Department files.
Right. So when you pull up this file, you're not just reading it for color. You're looking for a specific forensic detail.
And it's there. A line item.
It's a line item regarding electronic surveillance, which is abbreviated in the document itself as ELSUR.
ELSUR. ELSUR.
Exactly. Now, in the context of federal investigations, DOJ record keeping, ELSUR is not a casual term.
This isn't somebody's note in the morans.
Not at all. It doesn't refer to someone, holding a camcorder at a party or a nanny cam in the living room. ELSUR records implies something much more formal.
It implies a system.
A systematic, logged, and often authorized method of monitoring. It implies a database of recordings. It's procedural.
And the document explicitly connects this term, ELSUR, to a CRS search.
Which is another key piece of jargon. A CRS search, it usually refers to a Congressional Research Service search, or, more likely here, a central record system search within a federal agency.
So what does that connection tell you as an auditor?
It tells us that the surveillance system, whatever it was, wasn't just a private project existing in a vacuum on an island. It was logged in a government system. The government knew there were electronic surveillance records associated with this case. It was indexed.
Let's break that down, because the distinction between just surveillance and ELSUR is the whole ballgame here, isn't it?
It really is. I mean, you can put a Ring camera on your front porch. That's surveillance.
Right.
But that does not generate an ELSUR record in a Department of Justice database. ELSUR implies a formal procedural interaction with the federal government, usually the DOJ or the FBI.
So it's been cataloged.
It's been cataloged. It usually involves what are called the electronic surveillance indices. These are maintained to track things like non-consensual interceptions, court-ordered wiretaps, microphone installations, things that require warrants or specific intelligence directives.
So the very existence of an ELSUR hit on a subject means the federal apparatus has, at some point, interacted with electronic monitoring regarding that person.
Yes, it's a flag in their system. So finding this specific acronym in document 24032, it fundamentally changes what we're looking at.
We're not looking at amateur on video anymore.
We're looking at a system that the government itself had indexed. We're looking at a system that generated a paper trail. If you're an auditor, you always look for the purchase order, the invoice.
And the ELSUR record is that invoice.
It's the purchase order for electronic monitoring. It confirms that the capability to record was not just a rumor. It was a known variable to the investigators on the case.
Okay, so that's one document. Let's cross-reference it. We have another file, EF1000188515.pdf.
And this one provides the corroboration on the physical side of things, the security environment.
It's a document that deals with conditions of confinement, security protocols.
Right, but when you read between the lines, it reveals the capability of the entire operation. It specifically mentions, and this is a quote, home detention with electronic GPS monitoring.
Okay, on its face, that sounds pretty standard for a high-profile defendant. Bail conditions.
It does, but then you read the next line. It also cites the presence of private armed security guards.
And that's where it gets interesting.
That's where it gets very interesting, because now you have a convergence of two critical data points.
You have document 24032, which gives us the ELSA records, proof of electronic surveillance data being indexed by the government.
And then you have document 105 which establishes a physical environment that is completely controlled by private armed security and electronic monitoring systems.
It establishes the baseline capability.
Exactly. If you're auditing a business, the first question you ask is, does this factory have the machinery to produce the product they claim to make?
And in this case, the product is compromised information. Leverage.
And the ELSR record proves the digital machinery existed. The private armed guards prove the physical machinery existed to protect that digital machinery. The infrastructure for monitoring wasn't theoretical. It wasn't a rumor from a tabloid. It was a line item in a government file.
And that detail about private armed security in document 18515, it's significant because of the chain of command, isn't it?
It's absolutely critical. Standard Bureau of Prisons guards, they report up a government chain of command. They file government reports. Who do private guards report to?
The client, the person paying the bill.
They report to the client. In these high net worth home detention scenarios, the defendant himself is often paying for his own security, which, creates a whole host of conflicts of interest that are well documented in legal ethics.
But here, it does something else.
In this specific context, it creates a hermetically sealed environment, an information black box. The guards, the cameras, the visitor logs, the data from the monitoring systems, it's all proprietary.
It's not public record.
It's not public record until something goes wrong, or, as in this case, until we find a document like 1 Eaton 515 that confirms this setup was in place.
And that distinction is vital, because now we can move from the simple existence of these systems to their application.
Right. Having a camera is one thing. We all have cameras on our phones. Using it to build a library of leverage, that's something else entirely.
Which brings us to the recording infrastructure itself, the next layer of the audit.
For this, we have to turn to the interview transcripts. Specifically, the document labeled Interview Transcript Maxwell 2025.07.24, redacted.pdf. There's also a CFT version of that same file.
These transcripts they're dense, and they are very heavily redacted, huge black boxes everywhere.
They are, but we're not just reading them cold. We're looking at the index of the database which guides us. It points to specific page numbers, 164, 166, 174, and 176.
So the index is like a roadmap. It's telling us what the Department of Justice itself flagged as important.
It's the government's own table of contents for the key evidence, but there's a very specific entity mentioned on page 201, line 15, that requires our full attention.
And that entity is?
The entity is Blackhawk.
Blackhawk. It just appears there in the transcript in the context of the operations infrastructure.
It does. And in the world of private intelligence, private security, these names matter a great deal. While the transcript is heavily redacted around the full context, the mere mention of Blackhawk is significant.
Why? What does that name suggest to you?
It suggests the involvement of a highly specialized entity, almost certainly involved in security, intelligence gathering, or secure data management. You don't hire a firm or use a code name with that designation to, cater a dinner party.
You hire them for security infrastructure.
And not just any security infrastructure. We need to contextualize what Blackhawk means for the listener. This isn't your local ADT alarm installer coming to put a sensor on the window. No. Entities that operate at this level, they're often referred to as corporate intelligence firms or even private military contractors. They provide a completely different tier of service.
Like what?
They provide things like offensive due diligence, counter-surveillance sweeps, and most critically here, they provide the installation of secure, closed-loop recording and data storage systems.
So if you see the name Blackhawk in a transcript discussing the operations of these houses,
you are looking at professionalized intelligence gathering, not just domestic security to stop burglars. You're looking at a system designed for collection.
And when you look at the broader transcript, the pages referenced in the index, the line of questioning, it explicitly connects this infrastructure, this recording capability, to the concept of leverage.
And that is the audit point. You're always looking for intent. The transcription strongly suggests that the collection of data on individuals inside the properties was an active process.
It wasn't just a passive security camera running in the corner.
No. The questions being asked in that transcript, which we can infer from the index summaries, they all circle around the use of this infrastructure. The investigators are trying to follow the data.
Right. The questions on pages 164 through 176, it looks like they're drilling down on the flow of the data. Where did the tapes go? Who had access? Who viewed them?
Exactly. You do not ask those questions about a security camera that's just pointed at the front gate. You ask those questions when you believe you're looking at an asset collection system.
The investigators in that deposition are treating the recording infrastructure as a mechanism.
A mechanism for generating a product. And the product, according to their line of questioning, was compromising information on the guests.
Okay, so let's recap. We have the hardware established by the ELSUR records. We have the operators, the private arm security, and the specialized entities like Blackhawk.
The capability and the personnel.
So now we have to look at the output, the product itself, which brings us to the core question. Who had leverage over whom?
And this is where the file labeled EFTA 02521019.pdf becomes, I would argue, the single most critical document in this entire cache.
Before we dig into that specific document, let's go back to the Maxwell transcripts for one more piece of context.
Okay.
The database index summary. The government's own summary of these transcripts. It's blunt.
It is. It reads, and I'm quoting directly from the summary, "This notion that he blackmailed men, potentially to blackmail them."
That's not an interpretation. That's not a journalist's take.
No, that is the government's own summary of the content of the file. They are stating that the core subject of the interview was the potential for blackmail.
And we have specific citations in the transcript itself. Page 73, line 23, the word blackmail.
And page 73, line 8, the word blackmail.
Then again on page 86, line 25, blackmailing.
The repetition there is significant. In a deposition or an interview transcript, that kind of repetition indicates a line of questioning that the investigator is pursuing aggressively. They are not asking about blackmail 3 separate times, dozens of pages apart, by accident.
They're trying to map the flow of information.
They're trying to establish that blackmail was the operational currency of this entire enterprise.
And we should pause on the legal strategy there for a moment. If an investigator asks a direct question, did he blackmail anyone? And they get an evasive answer.
They will come back to it. They'll circle back, rephrase it. The fact that it appears on page 73 and then again on page 86, 13 pages later, it suggests the witness was either not providing a straight answer or the investigator was trying to pin them down on a specific definition or a specific event.
Or they were just establishing a clear pattern.
It could be that too. In forensic interviewing, you often loop back to the core alleged crime to check for consistency in the story. And the core crime here, according to the focus of this transcript, is blackmail.
It's not just the underlying sexual abuse, it's the use of that abuse for a secondary purpose.
Coercion. The transcript proves that the authorities were investigating the coercion as a distinct and perhaps primary operational goal.
Okay, now let's go back to that key document, EFTA 02521019.pdf. You said it was the most critical file. Why?
Because of a specific phrase. 2 words that are capitalized when they shouldn't be, unless they mean something very specific.
The phrase is extortion process.
Capital E, capital P.
Extortion process.
Yes. In any kind of legal or, bureaucratic writing, you capitalize proper nouns. You capitalize the names of official programs, the names of departments. You do not just capitalize a general criminal act.
Unless you're referring to a specific defined operation, a file title.
Precisely. The document states it is more appropriately called the extortion process.
The syntax there is telling. It is more appropriately called.
Think about the weight of that. It suggests that within the investigation, within the files they were reviewing, there was a defined workflow that was actually labeled the extortion process.
It wasn't just random acts of coercion. It was a process. It implies a flow chart.
A flow chart. Step A leads to step B, which leads to step C. It implies a standard operating procedure.
If it were just a description of a behavior, it would be lowercase. His extortion process.
Correct. But capitalized, it reads like a project title. The extortion process. It strongly suggests that the people who were reviewing these files had identified a repeatable, formalized mechanism.
In this same document, it goes on to map that process to other external entities. It specifically mentions Pool and the Center for Security Policy's Team B.
And this is a crucial network mapping node. This is where the audit trail leaves the island and connects to the mainland, so to speak.
Team B and the Center for Security Policy. These are not random names.
No, these are external policy and security groups. By linking the extortion process directly to these names, the document establishes a connection between the leverage mechanism, the blackmail, and external security policy entities.
We should probably define Team B, just for clarity. Historically, that term has very specific connotations in the world of intelligence.
It does. Historically, Team B refers to a competitive analysis exercise. You bring in a group of outside experts to challenge the established intelligence community's assumptions on a major threat.
The most famous one was in the 1970s, regarding the Soviet threat.
Exactly. And the Center for Security Policy is a well-known think tank in Washington, D.C., focused on national security issues.
So the question the document forces you to ask is, why are these names appearing in a file related to a sex trafficking and extortion operation?
That is the multi-billion-dollar question. It removes the operation from being solely about one predator's personal gratification, and it places it squarely into a sphere of political and policy influence.
If your extortion process is being discussed in the same breath as national security policy teams,
then the implication is that the product of the extortion, the leverage, was being used in that arena.
Right. If you're running a formalized process that's linked to security policy teams, you're not just a garden variety criminal anymore. You are either an asset or a liability in a much, much larger game.
The leverage isn't just pay me money or I'll release this tape. The leverage becomes change this government policy or grant this security clearance or vote this way on this bill.
Which is the perfect transition to our fourth evidence block. We need to be very clear about distinguishing what we can strictly prove with these documents versus what remains, for now, speculation.
The known knowns and the known unknowns.
Exactly. And for this, we have to look at the Deep Capture series of documents. It's a range of files from EFTA 0000305.pdf all the way through EFTA 000002904.pdf.
Right. And these documents, they repeatedly reference an investigative reporter who is associated with a project or entity called Deep Capture. But what's important for our audit is the specific financial terminology they use to describe the entire operation.
We're looking at the financial structure. I mean, crimes at this scale, they require a massive amount of liquidity. They require ways to move funds that can't be easily traced.
The slush fund.
The documents explicitly link the operation to a structure they describe with 3 words.
Extortion, Ponzi, slush.
The slashes are important there.
Very. Extortion / Ponzi / slush. It's not 3 separate things. It's a 3-part integrated system, a trifecta of financial malfeasance.
Let's break that down. Extortion is the asset generation. It creates the control, the leverage.
Right. The Ponzi might refer to the investment structures he used, to lure people in or to launder the money from the extortion. But slush is the most interesting and I think the most operationally significant term.
A slush fund.
A slush fund is, by definition, money that's set aside for illicit purposes, for bribes, for payoffs, for off-the-books operations. The fact that these documents prove the investigation was looking at an extortion slush fund is critical.
Because slush implies a total lack of accountability. It's a pool of money that doesn't have a line item in any public ledger.
It's operational cash. You use a slush fund to pay the private security teams we mentioned earlier. You use it to pay off potential witnesses. You use it to fund the logistics of running the extortion process.
So the document, using that specific word, slush, it links the financial crimes directly to the operational crimes. It's the fuel for the engine.
Exactly. And then these same documents give us a potential destination, or at least a point of intersection for that influence. There's a repeated textual reference to the handling of White House security clearances.
Let's pause on that for a second. This is a crucial fact-check moment. A lot of people hear White House and Epstein in the same sentence, and they immediately think of, wild internet forums and conspiracy theories.
Right.
But this isn't that. Here, in document EFTA 000010305.pdf, it is a direct textual reference within an investigative file.
It's not a theory, it's a documented fact that the investigation's scope included the intersection of Giuffre Epstein and the process of handling White House security clearances.
It puts the entire issue of security clearances squarely into the documented investigative scope. It makes it a legitimate area of inquiry.
Correct. Now, it's important to be precise. The document doesn't tell us whose clearance was compromised. It doesn't prove that a clearance was granted because of blackmail.
But it proves the investigators were asking the question.
They were asking the question, did this extortion machine impact the highest level of our national security credentialing process? The very fact that that question is in the file is a major finding.
And that itself is an audit finding. The investigators, who had access to far more information than we do, considered it a valid line of inquiry.
And you do not investigate White House security clearances on a whim. There had to be a nexus. There had to be some credible information that created a connection between the subjects of the extortion and the people who either held or were in a position to grant those clearances.
So let's connect the dots we have so far. We have a documented extortion process, we have a slush fund to finance it, and we have a documented investigation into its potential impact on White House security clearances.
The next logical question for an auditor is, what did the institutions do with this information? How did they handle this incredibly sensitive material?
And this brings us to what might be the single most damning phrase in the entire archive. We are going back to that critical document, EFTA 02521019.pdf.
It's a very short phrase, 4 words, to sanitize the PA's records.
Sanitize.
Sanitize. In an intelligence or legal context, that word has a very, very specific meaning. It does not mean cleaning up a spill or correcting a typo.
It means the deliberate removal of sensitive data. It means redaction. It means deletion.
It means making a record clean for public consumption or for interagency review. You sanitize a file to remove sources and methods or to remove compromising information.
The document explicitly links this action, this sanitization, directly to the extortion process.
That's the chain of custody. You have the process, and then you have the decision to clean up the records of that process. This is a recorded institutional decision. Someone, somewhere, at some level of authority, made the decision that the PA's record needed to be sanitized.
Any idea what PA stands for?
It's not definitive from the context, but it could be principal agent, prosecuting attorney, or even public affairs. Whatever it stands for, the context suggests it's a key figure in the case. But the act of sanitization is what's important. It implies that the raw, original record contained information that could not be allowed to see the light of day.
And let's be clear about the word. Sanitization is distinct from redaction, isn't it?
Very distinct. Redaction is usually visible. You see the black bars over the text. You know that information was there and it was removed.
Right.
Sanitization is often about removing the existence of the data entirely. You rewrite a paragraph. You remove a whole page from a report. You alter the summary so it looks like a meeting never even happened. It's a proactive and much more deceptive alteration of the historical record.
Which means we have to ask who authorized it, because that is not a low-level decision. You don't let a junior clerk sanitize a file that involves White House security clearances and a named extortion process.
From an audit perspective, this is a fatal flaw. Once you introduce a documented order to sanitize into the workflow, the integrity of the entire archive is compromised. You can no longer trust what you're seeing because you have no idea what is missing.
It creates a break in the chain of custody for the evidence.
A deliberate break.
Yeah.
And this connects to the broader file dump that was mentioned in the source material, the EP 589 source. This source references the 2015 court documents that were released related to Ghislaine Maxwell. Pronounced, of course, G-Bang.
Right.
And when those files were unsealed, we saw a long list of high-profile associates mentioned. Prince Andrew, Alan Dershowitz, former President Bill Clinton.
And we need to be extremely precise here again. We are not stating, based on this specific sanitization document, anything about the guilt of those individuals regarding the underlying crimes.
No. We are doing something much more limited and factual. We're stating that their names appear in the released files, and we are stating that these files exist within an ecosystem where we also have a documented protocol to sanitize records.
The institutional failure is the creation of a shadow archive, an unreliable record.
If you have a formal decision to sanitize, you have an admission that the evidence is being actively managed and altered. You cannot have a credible investigation if a primary directive is to scrub the subject's record. It's an administrative failure documented in black and white.
And that sanitization, that deliberate creation of holes in the record, leads us directly to the final evidence block, the gaps.
Because if you sanitize a record, you create a hole. And in this case, we can actually see the holes in the database structure itself.
We're looking now at the description of the pinpoint database structure. And the overview of the data dump contains a very, very unusual admission.
It does. It reads, and this is a quote, "The U.S. Justice Department has begun to release and then delete documents."
Release and then delete.
That is not standard archival procedure. That is not how FOIA works. You don't release a file to the public and then claw it back unless it was a major error, or unless it revealed something it was never supposed to.
And we can actually identify the missing data sets by their numbers. The files are organized into sequential data sets. We have data sets 1 through 8, and we have data set 12.
Which begs the obvious question, where are data sets 9, 10, and 11?
They're missing. Gone.
A gap of 3 full sequential data sets in a numbered release. That is not a clerical error. That's a block of evidence that was processed, numbered, and then deliberately withheld or removed from the public release.
In any kind of sequential database, numbers are assigned as the files are ingested into the system. So if you have 1 through 8, and then you have 12.
It means 9, 10, and 11 existed at one point. They were created, they occupied digital space, they contained files.
And then they were removed. The gap isn't just an error, it's a footprint. It's the goes of removed evidence.
And the database description gives us a clue as to what might have been in those missing files. It specifically notes that there were items deleted by the DOJ that connect Epstein to President Donald Trump.
Okay, this is where the strict audit rule is paramount. We have to state only what the log indicates.
That's right. The database logs indicate that files with this description were present, and then they were removed. We do not know the content of those files. We have no idea if they were incriminating or exculpatory or completely benign.
We only know the administrative action that was taken.
Deletion. But the timing and the specific tag on that deletion, that matters. If files connecting the subject to a sitting or former president are deliberately deleted from a public release, that is a high-level administrative action.
And it aligns perfectly with the sanitization directive we saw in the other document.
It's the execution of that directive. If the order of the day is to sanitize the record, then deleting files that connect to high-profile political figures, and that would apply regardless of their party, is how you would carry out that order.
But when you combine the explicit mention of deleted files with the unexplained gap of datasets 9, 10, and 11, you have a clear pattern.
A pattern of information removal. And it brings us full circle back to the speculation in that very first document we discussed, EFTA AL0000032.pdf, the file where the investigators themselves were wondering about potential blackmail material.
The quote is, "Wonder whether potential blackmail material played."
The gap is the physical location of that material. The ELSU records prove the system existed to create it. The extortion process document proves there was a workflow to use it. The sanitization order proves there was a concerted effort to clean the record of it.
And the missing datasets 9 through 11 are the most likely place where the product of that entire process would reside.
It's a void where evidence should be.
So let's synthesize this. Let's walk through the 6 blocks of evidence and stack them up as a clear chain of documented facts.
Let's do it. Block 1, we have proof of surveillance, the ELSR records. The eyes and ears of the operation were real, and they were logged by the U.S. government.
Block 2. We have proof of a professionalized recording infrastructure, the Maxwell transcripts discussing the use of the systems, and the mention of a specialized entity like Blackhawk. The mechanism was active, not passive.
Block 3. We have a named operation, the extortion process. Capitalized, formalized. It wasn't random, it was a repeatable procedure, and it was connected to external entities like Team B.
Block 4. We have a documented connection to the highest levels of power. The investigative scope in writing included national security and the handling of White House clearances.
Block 5. We have a recorded institutional decision to cover it up, the explicit directive to sanitize the record in order to alter the evidence.
In Block 6, we have the physical holes in the archive where that evidence should be, the deleted files, and the unexplained disappearance of datasets 9, 10, and 11.
When you stack them up like that, the pattern is, it's undeniable. This isn't a chaotic mess of random, unconnected crimes. It's a clear timeline, an operational flow.
Capability leads to methodology.
Methodology creates liability.
And liability leads to institutional cover. That is the story these documents tell, from beginning to end.
The surveillance wasn't accidental. That was the capability. The extortion wasn't incidental. That was the methodology. And the sanitization wasn't a mistake. That was the institutional cover-up.
And that capitalized phrase, extortion process, that's the key that unlocks it all. It transforms the public theory of blackmail into a documented administrative reality. The authorities saw it, they recognized it, they named it.
And then crucial parts of the record regarding that process were made to disappear.
So that's the state of the evidence as it stands today. The mechanism is proven through the paper trail. The specific tapes, the actual blackmail material, are missing from the current public data sets.
But the footprint of the blackmail machine, it is stamped all over these PDFs.
Next time, institutional failure.
You have just heard an analysis of the official record. Every claim, name and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.